Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous William Porter.
Wow, thanks, Jesse. What an introduction. I don't know if I can live up to that, but I'll do my best. Anyway, today we're going to be talking about, well, let me get into a couple things here. We're going to talk about what happens after I record my lien. How do I get paid? Okay, so I recorded a lien here in California. And so if you have any questions, there's a chat box, and Jesse will deal with that, I think mostly at the end. And don't include any company names in the questions so that everybody doesn't see who you are. There's a legal disclaimer. We're talking about broad subjects here. If you need any detailed legal advice on a specific situation, please be sure to call an attorney, preferably one who practices in the area of California construction law. All right. So in talking about what you do after you record your lien, so first you're going to record your lien, but then after you record your lien, it's very important in California that you have to calendar out for yourself. You have to file a lawsuit on foreclosing on the mechanics lien within 90 days after you record your lien. That's the first step. It's very important to get that down. Next, you need to do your very best to resolve the situation and get paid before the 90 days expires. This is the best time to do this because you recorded a lien, you've established all your legal rights to sell the property where you did the work, which is really great leverage. Yet at that time, during that 90 days, you're not yet paying attorneys to do a lot of work for you. Okay, so it's an economical time. That's really important to just, once you record the lien, the other party gets served with it, they know about it, it's the best time to resolve things, and avoid paying attorneys, avoid paying people like me. I'm really happy when, by educating people, I can get them to save money because that's a huge part of my job. Okay, now, there's something called a notice of credit. With the notice of credit, and we'll get into all this in detail in the next few minutes, but you can actually extend the lawsuit deadline, but there's a lot of rules on using a notice of credit. One, you have to get the owner to sign a document before a notary, and then you also have to record that document, and you're only going to be able to extend the lawsuit deadline for a year from when you last finished your work. Okay, let's say that you don't get it resolved and there's no notice of credit, then you got to go to court. All right, let's say then you win. So okay, you won the court case. What then? Because that's part of this too. You're going to get your judgment, which is something you get from the court, but then that still doesn't put money in your pocket. Then you have to go and do some things. You have to get an abstract of judgment in California. Then once you have an abstract of judgment, you can record that in various counties where they have property. You can go after bank accounts. You can go after defendants' personal property, their residence, their vacation homes, their cars. You can tap their paycheck. You know, a lot of things you can do once you get an abstract of judgment. And these are all steps in the process. SunRay has some resources, but anywhere along the process, and I'll follow these steps, almost always before you even get to the abstract of judgment, even the judgment, things are going to resolve. But in case they don't, you got to bring it to the abstract of judgment phase. And then you can levy on all kinds of assets. And if you need help with that, attorneys do that, collection agencies do that. At that point, you've done most of the work for the next professional to take over. Okay, going forward, giving some more detail to what I've discussed already, you're going to record your mechanics lien, and then you have to file a lawsuit within 90 days. Okay, that's, as I mentioned, that's really important because the lien will expire, and owners and general contractors, if you're a sub or supplier, they're just waiting for you to miss the 90 days. So as you're negotiating, there are things that you can do. after you record your lien, you tell the other party, you say, hey, listen, you owe me this money. There's no back charges. There's no reason for you not to pay me. And I don't want you to think Mr. Owner or Mr. GC or Mr. Contractor who owes me the money. I don't want you to think I'm going to miss the 90-day deadline. So if you're thinking of that, forget it. And then you look to things like, and it's another subject, but there are some things you can look up in California. Look up prompt payment remedies. Things like this, prompt payment remedies can give you attorney fees when you win, even if your contract doesn't say attorney fees. Also, you can get interest on what they owe you of 2% a month, and sometimes 2% a month plus your contractual rate, which your contract might say up to maybe 1.5% a month. Plus 2% a month, that's 3.5% a month, that's 42% interest. So during this 90 days, you can say to the other party, hey, look, I'm not going to miss my lien deadline. Just dissuade yourself from that fantasy. Also, I'm going to sue you. And you know what? When I win, you're going to pay not only your own attorney, you're going to pay for my attorney too. You're going to be paying both sides of the attorneys, plus you're going to owe me 2% a month prompt payment interest, plus my contractual rate of interest. So why don't we just get this resolved right now so we don't have to go down the path? So those are the kind of things that you do during that 90 days. You just put your best foot forward and don't let them think they can push you around, all right? This is when you have the most leverage. Okay, you can record a document. It's called a notice of credit, and there's one on our website at porterlaw.com. And I'm not sure if SunRay does this. Probably they do. Okay, but if you're going to extend the deadline for filing a lawsuit with a notice of credit, then what you're going to have to do is look at these statutes, and it's easy to look up California statutes. Civil Code here mentioned 8460. That's the code section you look to, and you could extend the lawsuit deadline for up to a year after you last finished your work. But note that the notice of credit has to be signed by the owner of the property before a notary, and then it has to be recorded. So you know, sometimes these are good. I don't use them very much, honestly, because it just often extends the inevitable, and sometimes it may lead to things like other people getting paid and you not getting paid because you agreed to extend the deadline. Sometimes the better thing to do, which is also a negotiation thing and gives you leverage, is go file the lawsuit. You know, you don't have to wait the 90 days to file a lawsuit. You can file it after you record your lien. You don't have to wait. It's not all that expensive. You should use an attorney to do it. And if you're a corporation or an LLC or anything like that, you have to use a corporation. But if you're a sole proprietor, you can do it yourself. But I wouldn't do it yourself because you won't be taken seriously by the other attorney because they know all the tricks and they're just not going to take you seriously. So use an attorney, have the attorney file and serve the lawsuit, and that'll put on maximum pressure. You'll have to pay a filing fee and whatever it takes to draft the lawsuit. The filing fees, I think it's like, I don't know, $600 or $700. There's changes depending on the county, and then the cost for drafting the thing, and then the other side has 30 days to respond. That's even more leverage. So these are things to do after you record the mechanics lien. Just don't go longer than 90 days. All right. Okay. As I'm saying, do your best to resolve the situation within 90 days. Okay. Noting here, if you do get a check and resolve it, make sure that the payment clears the bank. Okay. Before you do anything like release anything, like release, say, a mechanics lien or dismiss a lawsuit. Okay, and these are some reasons to get things resolved within 90 days. Okay, as I noted, you got a lot of leverage. You've not spent a lot of attorney fees. Compromise is usually cost effective. I'd say if you can give up some dollars to avoid having to go to full-blown lawsuit stage, then do that. Let's say you get a check. Maybe you have a settlement agreement. It's a good thing to do, but it'll cost you more. Let's just say that you say to them, okay, listen, folks, I know you owe me $50,000. I'll tell you what, get me a check by Friday for $45,000. You'll save $5,000. Once the check clears, I'll release the lien. Okay, and you can do that. Just don't get too close to the 90th day because somebody could stop payment on the check. Just be careful about that, okay? All right. We talked about the notice of credit a little bit. Again, that has to be signed before a notary. It has to be signed by the owner. Sometimes owners, and I didn't mention this yet, sometimes owners say, okay, I'll write you a letter saying that your deadline to file a lawsuit is extended. You go, well, okay, the guy wrote me a letter, he signed it and all that. Well, that's just a trick. It will not extend the lawsuit deadline. You've got to use the notice of credit. There's no substitute for it. So don't be tricked on that, all right? Okay, then, okay, let's say none of it worked. You couldn't get it settled. Then if your contract requires it, you're going to use mediation or arbitration, okay? And you're going to continue your resolution efforts. Don't actually release the lien. Let's say you have success. Don't actually release the lien unless the check and payment clears the bank. I have seen a number of cases where someone has sent a check, then that caused the person to release the lien, then someone put a stop on the check. And then it's too late for a mechanics lien claimant to file a new lien because the time periods for filing liens is passed. So just be careful with that. Make sure the check clears the banks. Sometimes you can use an escrow, and you can send to the escrow a release of mechanics lien or even a dismissal of the lawsuit for them to file, but you have to make it clear in your escrow instructions that they're not to file the release of mechanics lien or dismiss the lawsuit you sent them with the lawsuit dismissal document until you tell them that the check has cleared the bank. So at that point, you might be dealing with an attorney and then take their advice. And also sometimes attorneys can kind of act as an escrow. I do it myself sometimes. I'll collect in the mechanics lien release or the dismissal of lawsuit, and then I'll wait for my client to tell me that the check has cleared the bank. And in the meantime, I'm telling the other attorney, here, I have these things, and I'll send them to you, and I'll send them a PDF of them, but you can't record a PDF. It has to be a real release of mechanics lien with original signature and notary. Copies don't work. Anyway, and I'll hold it until the check clears. So sometimes you can use an attorney to do that. Okay? Let's say then you go forward and you go to court and you win, or maybe you go to binding arbitration and you win, and then it gets sent on to the court and they give you a judgment. Okay? The judgment would include judgment on the mechanics lien foreclosure. That means the owner is very threatened with having his property sold at that point, absolutely, because there's a judgment against them. You're going to want to get a certified copy of the judgment from the court. And then you call the other side and say, hey, look, I got this judgment from the court. I guess I'm going to go about now selling the property unless you guys pay me. So you better pay me pretty quick, or I'm going to go to you can go to the sheriff. The sheriff usually has programs to sell the property when you have a mechanics lien judgment. And then let's say, okay, they say, okay. They send you a check, the check clears. Then what you need to do is file a satisfaction of judgment document with the court. And for these, your attorney can do this, but if you're doing it yourself as a sole proprietor, you can find these. It's a state form that you can find. It's a court type form called satisfaction of judgment. You could fill it out and then you file that with the court if you're adept at that type of thing. And then that'll resolve the case and you'll be paid, and the lien will no longer be on the property, et cetera, et cetera. And you'll be done, and that'll be nice too. But let's say that you don't get paid and they don't care. Then even though you have the judgment from back here, you need to get something else called an abstract of judgment, okay? And that's why back here on this slide in the center, you see you have to get a certified copy of the judgment from the court. And then following various procedures, then you could get an abstract of judgment, okay? What you would do with the abstract of judgment, which would have the judgment attached to it on the back of it, is that you would record the judgment in the abstract of judgment against the property and arrange sale with the sheriff, but also you're going to want to record the abstract of judgment in all counties where other properties of the judgment debtor might exist, okay? Because you not only do you have a judgment to on the mechanics lien to sell that piece of property, but you can also pursue other properties that the defendant who now has a judgment against them have in the state. You could go against their bank account, you could go against their vacation home, you can go against their paycheck and all that, as long as you have the abstract of judgment. Also record it with the Secretary of State. It's really rare for things to get this far. Going through all these steps usually causes someone to say, geez, I better come up with the money. So it's just to tell you, it's really rare for it to get this far. I mean, even though I have been doing this for 30-something years, you know, it's not been that many times when it gets this far. Okay, let me see what else I have here. Okay, well, we're a few minutes early, but it leaves us time for some questions, and there's a small quiz that Jesse's gonna address you about. Very small, 2 questions.
Well,
Jesse?
first of all, thanks so much, Bill. That was really great. It was very informative. I appreciate you giving us all of that information. We do have a question that has come through. It says, can my California lien deadline be cut short if work stops on the project?
Okay, here's a rule on that, and this is the subject of something else. So, if work stops on the project for 60 days, okay, that can be deemed to be a completion. The deadline for recording a lien is 90 days after a completion of that type. Okay, so there are a lot of different ways to determine when you can record the lien. Let's say that there is a valid notice of completion on the property because it actually gets completed. Then substance suppliers, if they get notice of this, they generally have 30 days to record a mechanics lien, and a prime contractor would have 60 days to record a mechanics lien. And then then you have 90 more days to file the lawsuit. But specifically, if a project stops without finishing, and it stops with nobody at all working on the project for 60 days, then that can be deemed to be a completion. And then after that, everybody, contractors, subcontractors, suppliers, all have 90 more days after that 60th day to record a mechanics lien. And then after that, everything goes like normal.
Okay, perfect. Thank you. Yeah, thank you so much for clarifying that. Another question came through, and it says, is a written contract required to file the mechanics lien?
No, not at all. Not at all. Sometimes, and many things can be considered a written contract. You could have an exchange of emails. You could have a purchase order, which is a contract. So what you need for a contract is you have to have an offer, you have to have acceptance of that offer, and you have to have some form of consideration. Usually somebody actually getting to work on the property or paying some money at all from one side or the other, because someone has incurred a detriment by going and working on the project. But no, it doesn't have to be any kind of a written contract, fancy or not. I will say this though, there are different contracts for different purposes. If you do any home improvement work in California, there's a very specific home improvement contract that you have to follow that follows the rules of the Business and Professions Code. And if you don't use a proper home improvement contract, then the Contractor State License Board will give you a citation if the owner of the property complains about you for any reason whatsoever. But no, you don't necessarily have to have a written contract. Written contracts are best, but they're not necessarily required.
Okay, awesome. Thank you so much for that. Let me see. All right, and then I have another question that came through. I know you've addressed this, but we'll go ahead and we'll pose it as well just to clarify for this individual. It says, can attorney's fees and filing fees be included in my lien amount?
Well, the filing fees are always included as costs. And when you win your case, you get your judgment amount and you get your costs generally. Now, the rule in California with attorney fees is that unless the contract says that you'll get attorney fees, or if there is a statute on point that says that someone is going to get attorney fees in a certain circumstance, you don't. it's like the English rule or something, where it's common law, and it has come down to us where you don't get attorney fees in most jurisdictions, almost every single state, I think, unless the contract says it or a statute says it. Now, the prompt payment remedies, they have specific provisions where you would get your attorney fees if you win your case. And those cases would be generally with prompt payment remedies if you have a contract with the owner and the owner doesn't pay you without excuse, or if you're a subcontractor or a supplier and your GC or the person above you gets paid, but they don't pass the payment on to you that you're supposed to be getting from their payment. Like, let's say they had a progress payment and it included your scope of work and the owner paid the GC and the GC didn't send it on to you but kept it in their pocket, then you're entitled to a prompt payment remedy. Also, whenever you have a contract with the owner, you're generally entitled to a prompt payment remedy if they don't pay you without excuse. But if you're lower level, then the person ahead of you has to get paid and not pass the money on to you. Then in that case, you get attorney fees, and you also get attorney fees if your contract says the winner of any legal dispute gets attorney fees. So that is generally a good thing to put into your contract if you tend to be correct in your position on who's responsible for the breach of contract. A lot of times GCs don't like to put in attorney fee clauses because on larger projects they have all these subs who are all going to get attorney fees when the GC loses, and then they lose their leverage. But other than that, most people, I think, should have an attorney fee clause to protect themselves. And in my practice, I represent both subs and suppliers and GCs. And honestly, it depending on the contractor, but I would say more often than not, the subcontractor is correct in their theories and would win the case than the GC.
Okay, awesome, wonderful. And another reason to have that written contract, right, is if you can get that clause in there to protect yourself. All right, I think that's all the questions that have come in thus far. If anyone does think of a question that wasn't addressed, please feel free to reach out to me. I'll be sure to answer any questions for you as soon as possible. Bill, can you go to the next slide for us, please?
A quiz.
There we go. So I'm here to test your knowledge. So take a look at these questions. If you feel like you know these answers, go ahead and put your answers into the chat. I'll send you guys out a little gift from SunRay. The first question is, if I have recorded a mechanics lien, what is my deadline to file a lawsuit to foreclose on the lien? And then the next question is, when is an economical time to resolve a lien foreclosure lawsuit? Take a look at those answers. If you feel like you know it, go ahead and put it in the chat for us, and I'll send you guys out a little gift. Bill,
we should at this point, we should have some of that Jeopardy music going.
I know, wouldn't that be wonderful?
See, I'll remember that next time. I'll just do it on my iPhone. All right.
That's fun. All right. Can you go to the next slide for me, please, Bill?
Yes, indeed. There we go.
All right. Here are some of the SunRay resources we have available for you guys to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these resources. If you're doing work in another state that maybe you're not familiar with, there's a state lien law guide on there that you can click on whichever state it is. Tell it if it's residential, commercial, estate job, what your role is, and it will kind of tell you exactly what documents those are and what the deadlines are that you need to kind of follow. So check out those resources to help yourself out. If you could go to the next slide for me, please. All right, our new service available is SR Receivables. We can help you with your collection needs. So if you have any jobs that you're needing help with, please give us a call, send us over an email, and we'll be sure to help you kind of work through it and see if we can help you get some of that money back. Next slide, please. All right, the next webinars with Bill is going to be how to get the bonding company to pay. That's going to be August 22nd at 10 a.m. Pacific. And then the next one after that is don't sign a release unless it says this one thing. That's November 14th, again at 10 a.m. So go ahead and register for free at sunraynotice.com/webinars. All right. Next slide, please. All right, so if you are in the Sacramento area, we are so fortunate and excited. We're going to be hosting a live seminar with Bill to go over how to get paid faster with liens, bonds, and contracts. If you're interested, register at sunraynotice.com/seminar to get registered. Again, that's in the Sacramento area. We hope to see you guys there. It's going to be a really exciting time. We're going to go over a lot of really good information. Next slide, please.
Sure.
All right, if you don't mind, take a moment to review us on Google. We really appreciate any feedback you can give us. It helps to better our webinars, make sure we're getting the right content that you're looking for out there for you. And we hope to get this to more and more contractors and suppliers like yourselves. Next slide, please. All right, and that is all we have for you guys today. Thank you so much for everybody who was able to attend. Thank you again, Bill. You are really incredible. We hope to see everybody at our next webinar, and we hope to see you guys all signing up for that seminar in Sacramento. Thank you guys again. Have a wonderful and beautiful sunny day. Bye, everyone.
Thanks, everyone. Bye-bye.